Welcome to this presentation of the right of entry. My name is David Symons. I'm the manager of the prevention team at SafeWork SA. And firstly, I would like to acknowledge that we are gathered on the traditional lands of the Kaurna people. Today's presentation is a bit of an overview. I'll give you a bit of a background and the circumstances allowing for right of entry and the rights and obligations of both union officials and employers. The background is that SafeWork SA has entered into a new phase in work health and safety, and as being regulator, the new work health and safety laws has provided for the first time in South Australia an actual section on right of entry for union officials dealing with safety initiatives on sites. I'll go through those further on through my presentation, and it's all about the circumstances allowing for right of entry. What are the roles and responsibilities for those union officials, for the PCBUs, and their rights and responsibilities in working together to provide harmony and working through so that this section of the Work Health and Safety Act is applicable and is used authoritatively out on sites. And again, it's the rights and obligations of the union officials and employers. So the general requirements for the right of entry for a union official is that first of all they must hold an entry permit holder under the Fair Work Act of 2009 or the Fair Work Act of 1994. It is a must. They also must hold an entry permit holder entry permit under the WHS Act of 2012. They must be a union official. They must have had prescribed training. And that prescribed training is given on a number of initiatives, whereas that the Act and the regulations are then spoken about and are given the overtures of the entry permit holder on their roles and responsibility into the actual prescribed Act. They must enter during normal working hours, and also too that when asked they must provide the PCBU with their entry permit holder, entry permit. It is an imperative that when requested that they carry these on them at all times. They must also comply with all health and safety requirements whilst on site, as any other visitor on the site would have to prescribe to. They are not allowed to enter any residential premises, for this is not classed as a workplace. It is a residential premise, and whilst on site, a union official who is an entry permit holder must not obstruct or hinder any person at work. And giving an example of that hindering and obstructing of people at work, it is that they would have gone on site, understood that there's issues, and then decided that they would have gone over to another area and started obstructing their work whilst on site, unrelative to why they're there as an entry permit holder. And this gives rise to misrepresenting their rights and obligations whilst on site. As you can see on screen at the moment now, we have a sample notice of entry, and these are the notices of entry that an entry permit holder must provide to a PCBU as soon as they're on site, and giving the PCBU the reasons whilst they're on site. As you can see from the top, you've got a number of areas where the entry permit holder has to provide them with their name, their union, their actual workplace of where they're going to attend to, and the reasons why, their purpose why they're on that site. I will get to those purposes shortly. It is then any additional information that is then prescribed in that notice that they're able to then provide to the PCBU, which gives them rise for being on that site. The general requirements for a person conducting business or undertaking, which is commonly known as a PCBU, is that they must not, without reasonable excuse, refuse or unduly delay entry to a workplace of an entry permit holder who is entitled to enter the workplace. That is an imperative point, that this legislation entitles a person who has an entry permit to go on a work site when he or she sees a reasonable reason why they should be in there. A person must not intentionally, unreasonably hinder or obstruct a work permit holder in entering the worksite or exercising in their rights in the workplace. And when required, They must provide the entry permit holder with relevant documents and also access to employees. The legislation that surrounds the entry permit holder is Section 117, Section 120, and Section 121 and Section 122. There are another lot of sections in the Act, but these are the ones that we're going to concentrate today on this presentation. Now, Section 117 provides that there has been an actual or a suspected contravention of the Act. And in that, it is able to state that they may enter the workplace because they believe that there has been a suspected contravention of the Act which relates to or affect a relevant worker. And a work health and safety must reasonably suspect before entering the workplace that the contravention has occurred or is continuing to occur that involves a risk to health and safety of the relevant worker. And furthermore, when attempting to go in on site, that entry permit holder must give reasonable practical notice to SafeWork SA about its proposed entry before exercising his or her power, so that in order to provide an opportunity for SafeWork SA to then triage and attend if necessary at the time of entry. So what does this mean? Well, Section 117 means that a permit holder is legitimately entitled to enter a worksite. That is a given. They must reasonably suspect, which means that forms an opinion of information, either a complaint or a direct observation that there has been a contravention that has occurred and it involves a risk. The EPH must decide whether to give notice to the SafeWork SA, and also that SafeWork SA's policy indicates of whether they are going to attend. But what it doesn't mean is that the PCBU can prohibit the EPH from entering the worksite. And reasonable suspicion, as we said, is not an open-ended. It must be substantiated. I have been told by X that it's unsafe, or X has seen and clearly has described, as far as reasonably practicable, that in the context of the particular risk, it is foreseeable that they are allowed on site. The EPH also too is not obliged to contact SafeWork SA, but SafeWork SA's policy has advised them that they should, whereas then we are reasonably available if we are required to go on site. And also, ultimately, SafeWork SA is not obliged to go on site. We will triage it, and then we will make our determination of imminent risk and foreseeable future, and we would make that determination. The right of entry with document inspection is that at least 24 hours on the particular notice that we've seen previously must be given to a PCBU so that they can provide the PCBU so that they can get 24 hours notice for the inspection of documents. It's no use that an EPH rolls up on site and immediately wants to get documentation of particular issues when it may be back at the office, or it may be that it takes time for them to get that. So it is given the 24 hours. And also too, documents are not just given out willy-nilly. Documents are that they must be relevant to the suspected contravention that they are talking about in the reasons why an EPH is actually there. And they must also not be protected by law. If they are protected by law, then the documents won't be handed over. But also, copies may be taken within the confines of an applicable law. Section 121 talks about the right of entry to consult and advise an employees. And again, that requires a 24-hour notice. So we've gone from Section 117, which is an immediate on-site, walking on the site because of the actual or suspected contraventions of occupational work health and safety, to Section 120 with 24 hours notice, and also Section 121, which is 24 hours notice. So they must be provided to the PCBU, and notice must be given to the PCBU or the person in charge. And when we're looking at those, and you're talking about the what is the meaning of 121, well, the EPH has a right to consult with relevant workers about their safety issues, and they can warn of particular hazards and risk. But certainly that the EPH back in 121 cannot direct workers to or instruct them to do any work differently. They do not have the role, the capacity to be able to talk to them. They are purely advisory capacity, and they cannot talk to workers who do not choose to talk to them. So if they go on site and they want to talk to workers and those workers don't want to talk to them, then they have the right, the workers, not to talk to them. If any party during the right of entry dispute has the issues up above where we've talked about that there is to be no hindering or disruption to an EPH, but a PCBU sees fit not to allow a entry permit holder on site, then any party to that dispute can then ask for SafeWork SA to appoint an inspector to come down and assist within resolving the dispute. And this becomes Section 141. Section 141 talks about that SafeWork SA will provide an inspector to assist. And the word is assist. We can't arbitrate, and I'll get to that in a minute, but we can assist with the dispute on why there are issues, why an EPH is not being let on site by a particular PCBU. The only person who can authorise and will actually make orders is the authorising authority. And the authorising authority is the Industrial Relations Commissioner of South Australia. They deal with disputes in any way: mediation, conciliation and arbitration. And that comes down to 142. Examples of where people have not read the right of entry clearly is that at sometimes SafeWork SA is seen as the authorising authority. SafeWork SA is not the authorising authority. The authorising authority for entry permit holders to get their entry permits is the Industrial Relations Commission, and in so they take cartage of any dispute. We can be called up if there is a dispute into the Industrial Relations as SafeWork SA and provide evidential background on what actually happened on that particular site and be able to go forward with providing evidential evidence. But a person who can only provide orders is the Industrial Relations Commission. And situations in such where the authorising authority may deal with that, certainly is the advice that we've been given is the advice for the purpose of assisting the two parties in resolving their dispute. So from there, this gives you a short overview in the ways in which that SafeWork SA assists in helping out the right of entry of disputes.